Welcome to the Assize Seminar 2020. My name is Dr. Antje Pedain. I am a reader in criminal law and philosophy at the Cambridge Law Faculty and director of the Center for Penal Theory and Penal Ethics in the Institute of Criminology. My main research interests are in criminal law, penal theory, and sentencing. I have recently thought about the question how non-custodial sentences fit into sentencing theory on practice. In this context, I have looked into the breaches regime for these sentences. As you know, one of the most striking features of non-custodial sentences is their conditionality. The sentence is fixed provided it is complied with, but when its conditions are breached by the offender, a different and normally a more serious punishment from the one initially imposed by the court may befall him. So, obviously, the theory of punishment that can underpin these sentences must be able to handle that dimension of conditionality in a satisfactory manner. I will come back to this point at the end of my presentation. What I want to focus on for this forum of practitioners, policymakers, and academics are some really problematic issues that emerge from the nitty-gritty of the breaches regime for non-custodial sentences. I will concentrate on breaches of community orders, so I will be focusing on sections 151 and 152 of the Criminal Justice Act 2003 and on Schedule 8 to that act, as well as on the Sentencing Council's definitive guideline on breach offences, effective from October 2018, and its drafting history. These are the themes I want to develop. Do the breach provisions lead to excessive punishment? Excessive in the sense of disproportionately severe as a response to the crime committed, and excessive in the sense of unnecessary in view of specific sentencing goals. If so, to what extent does this risk arise from the legislation itself, and to what extent does it arise from how the Sentencing Council's definitive guideline on breach offences interacts with the legislation? My specific claims will be the following. Firstly, the current legislation opens up the real possibility of excessive punishment. The most striking example of this occurs in relation to the punishment of persistent offenders previously fined, a phenomenon I will call the ratchet effect. But the risk exists in relation to every occasion where breaches are dealt with by the court. And that is indirectly conceded by the legislator in Schedule 8 of the Criminal Justice Act 2003. The Sentencing Council's 2018 guideline on breach offences increases rather than decreases the risk that an excessive sentence will be imposed in consequence of a breach. This is so for the following reasons. The guideline is overly focused on the idea of sanctioning a breach. The very inclusion of breaches to community orders in a guideline labeled breach offences is telltale. Breaches of community order requirements or of similar requirements imposed in conjunction with the suspended sentence of imprisonment or of post-sentence supervision requirements are not criminal offences in their own right. No law makes them such. They are just breaches. That is different from breaches of some of the other types of orders dealt with in the same guideline, which are under the relevant applicable legislation offences in their own right. Think, for example, of Section 30 of the Antisocial Behaviour, Crime and Policing Act 2014, which concerns breaches of criminal behaviour orders. Here we read that a person who without reasonable excuse does anything he or she is prohibited from doing by a criminal behavior order, or fails to do anything he or she is required to do by a criminal behavior order, commits an offence, and punishments for that offence are specified. No similar provision exists in relation to community orders. It is, to say the least, unfortunate that these two types of breaches, those which are breach offences and those which are not, have been lumped together in a single guideline. This may have contributed to an equally unfortunate substantive focus in the breach guideline on how to sanction different types of breaches. The other point I want to make here is that in a way that is different from guideline-based sentencing guidance in ordinary cases, the very existence of a breaches guideline undermines the proper functioning of non-custodial sentences. This is because it is of the essence that of these sentences that reaction to the breach remains flexible and does not necessarily result in an increase in sentence severity. The legislative scheme quite appropriately permits such flexibility. The guideline, however, removes it in the case of willful and persistent breaches and thereby undercuts the proper functioning of these sentence options. The accidental removal of discretion in one particularly important subgroup of cases serves me as a launching pad for a wider critique of the guideline approach to breach sentencing. My wider point will be that having a discretion fettering guideline on breaches of non-custodial sentences as such creates issues above and beyond the issues that sentencing guidelines for offences generally bring with them. I will explain this point with reference to the function that breach sentencing should serve in light of the justification for the imposition of community sentences. So let's get down to the nitty-gritty and my first point, the prospect of excessive punishment. On an experienced barrister's public-facing website, one is told the following. Community orders can only be imposed for imprisonable offences. As such, if an offence does not carry a potential sentence of imprisonment, a court cannot impose a community order. If only this were so. In actual fact, if you are a persistent offender previously fined, and you have committed an offence ordinarily punishable only by a fine, then the court can impose a community order on you. And if you then willfully and persistently fail to comply with the requirement of that order, you may even be dealt with by the imposition of a prison sentence not exceeding 51 weeks. If you don't believe me, read section 150A, subsection 1B of the Criminal Justice Act 2003, in conjunction with section 151, subsection 2, and paragraph 9, subsection 1C of Schedule 8. It is worth pausing here to appreciate the full import of this legislative scheme, which one can only describe as a deliberate act of legislative net widening. In a first step, community sanctions are made available for a persistent offender previously fined, whose fresh offence would otherwise also only merit a fine. So, by legislative design, the community order here intentionally replaces the fine for those insufficiently impressed by fines, and not a custodial sentence. The breach provision now ratchets this up a second time, making the persistent offender previously fined, but in this instance made subject to a community order, liable to imprisonment for an offence that was, in principle, only punishable with a fine when he has subsequently willfully and persistently failed to comply with the community order. From a proportionality perspective, it certainly raises flags that imprisonment is suddenly available as a sanction for a non-imprisonable offence, simply based on the fact that a non-custodial community order was an available sentencing option. Imperviousness to fines, when it comes to being deterred from reoffending by committing further fine-carrying offences, now not only opens up the offender to a more severe community order, but even, should he dare to willfully and persistently fail to comply with the terms of that order, to imprisonment for up to 51 weeks. Surely, at that point, the legislative scheme has lost sight of the proper relation between the punishment and the law. Recall that the offence would ordinarily only carry a fine, seriousness of the offence the court has set out to punish. This is an example of disproportionate results being invited and positively encouraged by the legislative provision itself. More relevant in practice is, however, the case where the offender has failed to comply with a community order that was imposed in a situation where the type of offence committed did open up the possibility of a custodial sentence, but the sentencing court reached the view that it could avoid the imposition of a custodial sentence by making a community order whose requirements were sufficient to meet the applicable sentencing goals. In these, we might want to think of them as standard cases of breaches of community orders coming before the courts. Paragraph 9, subsection 1 of Schedule 8 leaves to the sentencing judge a wide array of possible reactions, from the imposition of more onerous requirements, to the imposition of a fine, to resentencing the offender to a different sentence that was open to the court upon initial conviction. And in relation to that last option, it is clarified that a custodial sentence may now be imposed even when the offense did not initially appear to merit a custodial sentence. So on the one hand, the legislation makes it possible for the judge to sentence the offender who has breached the community order significantly more severely than she originally did. But on the other hand, the legislation also permits the judge to treat the offender much more leniently by fining the offender for the breach or by imposing a different set of requirements, albeit that one of these would be more onerous than the ones originally imposed. One would expect that the application of this provision in the absence of further guidance would involve extensive discussion between the offender and the court of the factors in play which resulted in non-compliance with the community order. And non-compliance wouldn't necessarily result in increased punishment. How does the Sentencing Council's definitive guideline on breach offences affect the situation? First of all, and that is the point I already made earlier, the overall framing of this guideline, breach offences, encourages the judge to think of his or her primary task in the situation as sanctioning the breach, which may not necessarily have been the perspective the judge would have taken after reading Schedule 8, which simply suggests that she needs to respond to the breach. The theme that runs through the Sentencing Council's response to the consultation, whether in the chairman's foreword or in the more specific answers at points made in the consultation responses, is the importance of sanctioning breaches, the idea that breaches undermine an order of the court and public confidence in sentencing, and that this is why robust sentencing is called for. It was only after heavyweight consultation responses to the draft guideline were acknowledged by the court. Sorry, I need to start this point again. It was only after heavyweight consultation responses to the draft guideline had forcefully reminded the Sentencing Council of the inappropriateness of failing to build offender-related considerations into the initial assessment of the seriousness of the breach, that the Sentencing Council conceded the need to do so, but only to a limited extent. No less than the Justice Select Committee had stated that a guideline that reminds sentencers to consider the offender's ability to comply with an order and the reasons for the breach is more helpful than the new guideline, which focuses mainly on the objective level of compliance with an order, prompted the Sentencing Council to grudgingly add consideration of, I quote, evidence of circumstances or offender characteristics such as disability, mental health issues, or learning difficulties which have impeded the offender's compliance with the order to the list of considerations to be considered by the court in assessing the level of compliance as falling into one of the 4 bands specified by the breach offences definitive guideline. These bands are willful and persistent, low, medium, and high. But the most disastrous misstep in the definitive guideline relates to the penalty it specifies for willful and persistent non-compliance. Revoke the order and resentence imposing custodial sentence, even where the offense seriousness did not originally merit it. No alternatives are provided. The appropriateness of this response had already been questioned by some respondents to the draft guideline. In reply, the Sentencing Council asserted the following. Some respondents questioned the proposed penalty for willful and persistent non-compliance, which aligns with legislation and directs that the offender be sentenced to custody, even where the original offence did not merit custody. The Council consider that the penalty would be appropriate in the case of an offender who has demonstrated such a level of disregard for a court order and who fails to engage, leaving the court with no alternative to a custodial sentence. It is, however, more than a little sloppy to assert, without further discussion, that the penalty aligns with legislation. In paragraph 9, subsection 4 of Schedule 8 to the Criminal Justice Act 2003, which deals with powers of magistrates' courts to respond to failures to comply with community orders, it is provided that where the court exercises the option of dealing with the offender for the offence for which the order was made, in any way in which the court could deal with him if he had just been convicted by it of the offence. In other words, when it deals with it by resentencing the offender, the court may indeed, I quote, in the case of an offender who has willfully and persistently failed to comply with the requirements of an order, impose a custodial sentence, where the order was made for an offence punishable with such a sentence, even though the court had, on the previous sentencing occasion, reached the view that the offence did not merit a custodial sentence. The operative word in the provision in the schedule is may. The court may do this, although it is quite obviously problematic. The sentencer will, after all, need to justify a punishment that is more severe than the one initially thought justified in response to the offence. But the schedule permits this. What would really help sentencers at this stage is some guidance as to the more fine-grained considerations that should lead them to exercise their discretion in the direction of severity increasing custodial sentences that is now open to them. But the guideline, instead of offering such guidance in respect of the exercise of this discretion, instead effectively removes it and makes the imposition of a custodial sentence the standard, the required response, every time the court deals with willful and persistent breaches. That is not guidance, and certainly not guidance that aligns with the spirit and wording of a legislative instrument that, for good reason, uses the word may and not the word must. This is already bad enough, but it gets worse. The guideline category of willful and persistent non-compliance with a community order can arguably also be hit by that character I've already told you about before, the persistent offender previously fined, whose current offence was only punishable by a fine, but who has been given a community order, with which he has now willfully and persistently failed to comply. As I have already mentioned, Schedule 8, paragraph 9, subsection 1c now permits the courts to imprison this offender up to 51 weeks. But, as I also stressed, the schedule only permits it. On reading the definitive guideline, however, one must be afraid that even this offender gets lumped into the top category of breaches, with sentencers being told that they must impose imprisonment. It is astonishing that the Sentencing Council, in general rather sensitive to questions of proportionality, failed to realize that its guidance for this category of offender amounts to a systematic insistence of a level of punishment that no account of proportionality can give support to. To sum up, the effect of the breach offences definitive guideline is not, in respect of the important question whether to impose a prison sentence on the offender who has persistently and willfully breached their order, to guide this question, but rather to de facto restrict it to the point of removing it. A judge applying Schedule 8 directly would have had to give an individualized justification for picking the alternative imprisonment in every case where he picks this alternative. and a judge who gave as his reason for imposing imprisonment that in his court, anyone who persistently and willfully fails to comply with the requirements of a community order will be given a sentence of imprisonment, would have failed to provide adequate justification for this choice. But with the guideline in place, the position is turned on its head. Judges are in fact forced to take the view that now a prison sentence must be imposed. And while the legislative scheme invites and underpins an individualizing attitude to breaches, the effect of the guideline is to remove individualizing considerations as a requirement, and thereby to inappropriately curtail the power of the court to deal with willful and persistent offenders, by removing 3 out of the 4 possible ways of responding to these breaches from the court, preserving only the most severe option, which will arguably in many cases be disproportionate. And this now gets me to the most fundamental mistake of these guidelines, the assumption that when sentencing for breaches, the court should ignore mitigating or aggravating factors that were already taken into account when originally sentencing the offender to a community order. The Council seems to believe that this would amount to some form of double counting and woe to the criminal justice system that allows an offender to rely on the same mitigating circumstance twice over. But the very idea that this amounts to inappropriate double counting is mistaken. Sentencing for breaches of community orders must factor in all relevant factors pertaining to the original offending behavior, because the state is still and continuously engaged in determining what is the appropriate response to the offender's original crime. Now, this is done in light of additional factors relating to the breach of the community order, but that doesn't mean that the original offense and offender-related factors have become unimportant or somehow used up. The response, even in light of the breach history, must still be a proportionate and appropriate response to the original offense. And just as importantly, it is part of making sure that the court's original objective in imposing requirements of a community order to influence the behavior of the offender in a positive direction can still be met. Community sentencing is part of a dialogue of sorts with the offender about his offending behavior, and breach sentencing is embedded into that framework. This is what the current guideline misses, and why its mechanistic and standardized approach to breach of sentencing undermines the effectiveness of community sanctions. Thank you very much.